All right. Superior Court of Fulton County, London Judicial Session under Judge James Boris presiding. Court member, come over.
All right, thank you, everyone. Please have a seat. All right, good afternoon, everyone. Good afternoon, everyone in the courtroom. Samantha, are you ready? Let's go ahead and open our record. Then I'll have everyone introduce themselves. Samantha, just let me know somehow that you are ready to start our record. Can someone unmute her?
Hello, I'm here.
Okay, great. All right, ladies and gentlemen, this is the State of Georgia versus Garret David Rolfe. This is case number 20 CP 192494. I'm going to ask for some introductions in just a moment. I am first looking for the defendant, and it looks like he's not quite yet connected, so I'm going to wait just a moment.
We are connected, Your Honor. Lance LaRusso,
Okay,
I'm sitting
sorry.
with the defendant.
Okay, I'm sorry. I saw another microphone for Rolfe. All right, good. And can you hear me? You are on our screen.
We can, Your Honor.
All right. Again, I'm going to ask for some introductions in a moment, but I would just like to put a few things on the record as we begin. I am appearing, I'm the presiding judge for this week. I am appearing in courtroom 8A at the Fulton County Courthouse. Our courtroom is open to the public. We are, in fact, attended by members of the public today and by members of the media. We also, I understand, have an overflow area open to the public to be able to watch these proceedings, and therefore that is because our courtroom seating is limited due to the coronavirus, and we're trying to accommodate as much of the public interested in this case as possible. Everyone involved in the actual hearing itself, besides me and other staff in my office, are appearing via the Zoom video conferencing platform. We'll discuss a little bit more about that in a moment. I am going to ask, and I'm looking around and everybody is in good compliance, so I appreciate it, but I am going to ask everyone in the courtroom if you will please continue to wear your masks. So far you are doing a good job. Today's hearing, as I'm sure everyone involved understands and appreciates, is limited to one issue, and that is the issue of whether or not the defendant in this case is entitled to a bond. I am hearing this case under the authority of Code Section 17-6-1, which provides that a bond for certain offenses, including murder, can only be heard before a judge of the Superior Court. Inasmuch as this case is not yet indicted and therefore is not yet assigned to any particular Superior Court judge, our court policy provides that any bond motion filed in a case with such a charge will be heard by the presiding judge, and for that week, of course, this is me. We have a limited amount of time for this hearing. I do not anticipate that we will have live witnesses. All the parties on the Zoom camera right now should be those who have received a specific invitation. You can't see it, but you are on a larger television monitor here in the courtroom. I do want to suggest, we've all been, of course, all of us have been involved in a number of Zoom hearings. I am in a situation where my tile does not light up. My border is not going to work when I am speaking because I'm using the court microphone system or sound system. My experience on this has been that if you need to object or say something, or if I need to ask a question, I am simply going to raise my hand and try to get noticed, and that is about the best that we can do. I believe that I have hopefully reminded everyone of our limited purpose today. Council are aware of the factors to address. We are not determining the merits of this case today. The first question for defense counsel and for the defendant is whether the defendant waives his right to be personally present in the courtroom today.
Your Honor, he does waive his. This is Noah Pine speaking on behalf of Garret Rolfe, and Mr. Rolfe does waive his right to actually be physically present inside the courtroom.
Okay, and you are ready to go forward via this method?
Yes, Your Honor, we are.
All right. Then the initial burden is on the defendant. Would you like to proceed?
Yes, Your Honor. And if I could just give a brief procedural history, Your Honor, and set up the case for the record, and then Mr. Thomas will take over and discuss the factors for bond, if that's okay with the court.
Yes. Yes.
Your Honor, this is case number 20 CP 192494. And we are here on a motion for bond that we filed on behalf of our client, Garret Rolfe. And while this case has been reported in the news, I'd like to just give the court a brief summary of what got us before Your Honor today. On June 12th of 2020, Officer Devin Brosnan, B-R-O-S-N-A-N, responded to a 911 call at a Wendy's in reference to a male passed out. Officer Brosnan determined that Mr. Brooks was the male who was passed out, and Officer Brosnan, asked for assistance in doing a DUI investigation. Officer Rolfe is the one who responded to the DUI investigation, and in our brief that we submitted to the court, we actually gave you an exhibit, which was Exhibit A, which is a rough transcription of the entire exchange between Officer Rolfe and Mr. Brooks up until the point that Officer Rolfe told Mr. Brooks that he was being placed under arrest for DUI, or his exact words were, "I think you've had too much to drink, put your hands behind your back." And at that point, Officer Rolfe attempted to handcuff Mr. Brooks. Your Honor, I don't know what video evidence the state is going to present, but we would proffer to the court at the point of Mr. Brooks being placed under arrest, his demeanor changed. He attempted to break away from the officer, Officer Brosnan and Officer Rolfe. He began to fight with the officers. He actually punched Officer Rolfe in the face. He took Officer Brosnan's taser. He pointed that taser at Officer Brosnan's head and fired it. The only reason he didn't hit Officer Brosnan in the face or head is because Officer Brosnan blocked it with his hand. Officer Rolfe then pulled out his own taser and shot twice at Mr. Brooks as he was still right there with Officer Brosnan. Mr. Brooks took off running with Officer Brosnan's taser in hand. At some point, turned around, pointed that taser at Officer Rolfe, and fired the taser, at which point Officer Rolfe fired his weapon, his service weapon, at Mr. Brooks. We expect that the District Attorney's Office may try to present evidence that Officer Rolfe kicked Mr. Brooks. We expect that they're going to show you a still photograph. We've asked that they actually present the video that would show this kick. We deny that Officer Rolfe ever kicked Mr. Brooks. I don't even know how that's relevant for bond, but we would ask that they show the video. Additionally, I don't think any eyewitnesses indicated that there was a kick. The DA's office may also try to state that Officer Rolfe said something like, "I got him," after Mr. Brooks was shot. That's just simply not true. And again, we would invite the District Attorney's Office to play that for the court. We've already consulted an expert. We've determined that whoever said whatever was said was not Officer Rolfe. We do know from the video evidence that Officer Rolfe provided emergency medical attention to Mr. Brooks, attempted to save his life, and that's all captured on video. And then 5 days after this incident, before the GBI investigation was completed, the Fulton County District Attorney's Office had 11 warrants sworn out for Officer Rolfe's arrest. And they are the warrants that are before your court in 20 CP 192494, and that is felony murder, aggravated assault against Rayshard Brooks, 2 counts, aggravated assault against Melvin Evans, 1 count, aggravated assault against Daniel, D-A-N-Y-E-L, Killins, K-I-L-L-I-O-N-S, 1 count, aggravated assault against a Michael Perkins, P-E-R-K-I-N-S, 1 count. Mr. Evans, Killins, and Perkins were in an SUV that apparently was struck by one of the bullets that Officer Rolfe shot. They've also had him arrested for criminal damage to property in the first degree for the bullet hitting the SUV, and 4 counts of violation of the oath of office, one alleging that Officer Rolfe improperly used his taser, one alleging that Officer Rolfe failed to render aid, one alleging that Officer Rolfe violated his oath by shooting Mr. Brooks, and one that Officer Rolfe failed to render aid according to his oath. On June 19th, Your Honor, the day after Paul Howard held his press conference, I believe, or maybe 2 days after, we filed a motion for bond. That bond motion was originally scheduled for June 23rd of 2020, but at the state's request, it was continued to today. We also did file a motion for preliminary hearing on June 23rd, 2020. My understanding, from what we've been told from the clerk's office, is that this court is not conducting, not just Your Honor, that Fulton County Superior and Magistrate Court is just not conducting preliminary hearings at this time due to COVID, which is one of the reasons why we need a bond. On June 25th of 2020, we filed a motion seeking a written response from the state as to which 1761 factors they believe apply to deny bond. And since the state didn't respond, Mr. Thomas will just address all of the factors for the court. And then finally, yesterday, we filed a 2-page brief with some exhibits for the court to consider. Also, Your Honor, I did provide the court yesterday with 3 statements, and those statements were from the Georgia Sheriff's Association, I believe the Police Chiefs of Georgia, and the Fraternal Order of the Police, maybe. It was actually the Peace Officers Association of Georgia was the third one. And then also a packet of character letters. We sent them to Your Honor in the District Attorney's office yesterday so that everybody would have plenty of time to review them before this hearing. So I'm going to turn it over to Mr. Thomas, who is going to proffer and take care of the bond factors. And then after the state is done, I will finish the argument on behalf of Garret Rolfe, Your Honor.
Thank you, Mr. Pines. Mr. Thomas?
Thank you, Your Honor. Good afternoon. As a very preliminary matter, before I get to the bond factors, we've been provided this afternoon with a phone call that the state intends to play in support of its motion to detain Officer Rolfe without bond. We've reviewed that. The phone call is inflammatory. It is not purported to be a phone call from my client or anyone on his behalf. It contains certain racial epithets, and we would certainly understand that the rules of evidence are relaxed here, but it certainly has no relevance here, and so we would object to that. I assume that the court has been provided that in advance, but we would lodge an objection to that phone call being played. With respect to the 1761 factors, Your Honor, first, as Mr. Pines has indicated, we provided a number of character letters to the court on yesterday and to the DA's office. To the extent that those are not part of the record, we certainly ask that those be made part of the record. I won't read those into the record, but I would like to point out that these letters represent a very broad cross-section of individuals who know Garret Rolfe well. What they speak to is they speak to his character. They speak to his ties to the community. They speak to his professionalism as a police officer. And we believe that all of those letters are relevant in the court's consideration of the factors and whether or not Officer Rolfe is a flight risk, a danger, or has the risk of intimidating witnesses. Those letters include letters from individuals who are practicing attorneys with the Department of Justice, individuals who have known Garret for a year, and some practically all of his life. Some of those letters include, and I will just mention a few names again, there are 28 letters, and I understand that we have a limited amount of time. A letter from William Jordan. Mr. Jordan indicates that he has known Garret Rolfe since birth, and he has offered to the court that Mr. Rolfe is not a flight risk. Benny Pena, P-E-N-A, was hired as a police officer with Officer Rolfe. They've worked together. Officer Pena offers that he has never seen Officer Rolfe express any ill will towards anyone. Sergeant Thomas Gleason is a supervisor of Officer Rolfe. Notably, Sergeant Gleason indicates that he has always treated suspects with the utmost respect. Sergeant Andy Taddei, and I'll spell that Taddei, describes Officer Rolfe as being thorough, fair, and again, treating all suspects with respect. Lieutenant Jason Ryan, from the supervisor of Officer Rolfe, describes him as being trustworthy. Donna Reese has known Officer Garret for 18 years, and again speaks to the fact that he would show up to court, that he's not a risk of flight. Captain Jessica Bruce, another member of APD, a previous supervisor of Officer Rolfe, describes him as treating citizens with the utmost respect. Jay Nguyen, Nguyen, has known Officer Rolfe for a year and talks about him providing financial support when things were difficult for him. Notably, one of his supervisors, a previous supervisor, Sergeant Redmond Keeney, describes Officer Rolfe as a rookie, but when he was a rookie, that he had the character of a veteran. I believe it's Sergeant Keeney in his letter who describes Officer Rolfe as a person that Sergeant Keeney, goes to for professional advice. Sergeant Major Halsnick, and I will spell that for the court, H-L-A-S-N-I-C-E-K. Sergeant Major is not a member of APD, but instead is a retired Sergeant Major who has known Garret since he was in high school when he was in the ROTC program. He describes him as being a pillar of his community and as committed to serving his community. Terry Walker has known Officer Rolfe since he was 20 years old. He's a family friend, and again describes all of the character traits that we will be discussing today and that I've previously discussed. Again, not being a risk of flight, again, a pillar of his community and someone who should receive a bond in this particular class. I'd like to talk to you a moment, Your Honor, about Officer Rolfe's professional career as an Atlanta police officer. Officer Rolfe is a 7-year veteran of the Atlanta Police Department. He's been a police officer. He was hired on with APD when he was 20 years of age. One of the letters that the court has before it describes Officer Rolfe as being the youngest person in his class. He was the valedictorian of that class when they graduated. In addition to being a certified police officer, Officer Rolfe is one of 200 drug recognition experts in the state of Georgia. Again, one of the letters that is before the court describes the process by which it takes to become a drug recognition expert. The person who has talked about this in his letter describes it as it's akin to a semester in college with a high failure rate. Officer Rolfe was the valedictorian of his drug recognition expert class. During his career, his 7-year career, he's received several commendations for his work as an Atlanta police officer. Notably, in addition to working full-time as a police officer with APD, Garret Rolfe is also pursuing an undergraduate degree at Kennesaw State University, where he majors in criminal justice and psychology. He's currently, because of the situation that he finds himself in, he's currently withdrawn from classes, but at least until this incident happened, he was attending full-time and working full-time as a police officer. and maintaining a grade point average of approximately 3.0. We certainly think these things all speak to Officer Rolfe's character. With respect to his personal life and family life, it's important to note that Officer Rolfe is a native Georgian. He has grown up here and lived here all of his life, and the majority of his family resides here in the Atlanta area. Your Honor, while I understand that we are not here to decide guilt or innocence or to address the merits of the case, I do want to talk very briefly about the incident that brings us before the court. This is
In what
not
connection, Mr.
a
Thomas?
typical scenario
Mr. Thomas.
for individuals who are, yes, Your Honor.
In what connection do you feel that's appropriate at this point?
What I want to describe is that this is not that what occurred, and I know that Mr. Pines has gone over very briefly the facts, but I think what is significant with respect to considering the Ayala factors is that this is not a case where a defendant is before the court who is alleged to have woke up, decided to go out and commit a crime in which someone lost their life. So I don't think that the merits are relevant for this hearing, but I think it's significant to note that what occurred here, and obviously the state and the defense, we disagree obviously on the merits, but even taking the state's case at face value, this is not a case of someone who is a gangbanger who decided to go do a drive-by shooting. It's not a home invasion. It's not a burglary where somebody was killed in the process. What is significant is this is an officer who was in the performance of his duty. A suspect escalated a situation, and I don't think anybody disagrees that that's the fact, and a death resulted. So again, I think that, again, we're not here to decide guilt or innocence, and I'm not here to argue that. Certainly that will take place at another day and time, but I certainly think the factual backdrop that brings us here is significant. With respect to the Ayala factors, Your Honor, again, I have discussed with you the letters that are before the court. It is clear to me from those letters, and it should be clear to the court, that there is no danger that Officer Rolfe, who is a lifelong resident of Georgia, will not appear for any scheduled court appearances. Officer Rolfe is an officer, a former police officer now with the Atlanta Police Department. The letters all to a person, particularly with the ones who describe his professional life, have talked about his dedication and professionalism. I think one thing that is significant with respect to that is Officer Rolfe is a person whose job required him to appear in court. There's never been any suggestion that he has not met those obligations to the district attorney's office or to the solicitor's office and did not show up for court when he was called or requested. And as this court knows, I know this court has been on the bench for quite some time. It often requires often short notice for individuals to appear in court and to be here. It often happens without a subpoena, and Officer Rolfe has always answered those calls and has always shown up to do what he needs to do. There's nothing about Officer Rolfe's background or the circumstances of this case that would suggest that he is not willing to appear. There's nothing that would suggest he's a risk of flight. Notably, in this particular case, the district attorney's office followed, I think what some would argue is a somewhat unusual process by which he was brought before the court and charged. As part of that process, those charges were announced, and he was given 24 hours to turn himself in. Officer Rolfe did that. Not only did he turn himself within 24 hours, he met that deadline early. If there was any question about his likelihood to appear and to meet any court-imposed obligations in this case, his actions when informed of these charges should alleviate these concerns, as well as obviously his service as a police officer. I believe all of those facts weigh in his favor. I do not believe there are any facts that would suggest otherwise, and we would ask the court to make a finding that Officer Rolfe is not a risk of flight and that there is no danger that he will not appear for any court-imposed deadlines. With respect to the threat of danger, again, at the top of this, I discussed with the court the circumstances which bring us here. This is not a case where, again, an individual is alleged to have gone out, woke up, and committed some heinous crime. That is not this particular case. Officer Rolfe is an individual who was engaged in the performance of his duties. A situation escalated and unfortunately resulted in a death. There is nothing in his background. There is not a fact related to this case that would suggest he is a danger to any person, to the community, or to property in the community. In fact, the facts suggest otherwise. And again, I would refer the court back to the letters that we have proffered to the court on his behalf. Indeed, in this case, in terms of threat or danger, I think what is significant from the transcript that the court has before it is one can see the professionalism in which Officer Rolfe handled this matter up until, again, the situation escalated and he was forced to do some other thing. Officer Rolfe is not a threat. He's not a danger to the community. As the letters indicate, he is a professional at all times. He was a professional that night at all times, quite frankly. And I would ask the court to find that Officer Rolfe does not pose a significant threat or danger to any person in the community or any property in the community. With respect to the third factor, the significant risk of committing any felony, I certainly believe that the letters speak for themselves. I certainly think that Officer Rolfe's background, again, speaks for himself. There's not a hint that there is a significant, and I would dare say any risk of committing any felony of granted bond by this court. Obviously, Officer Rolfe has no criminal history, and again, I believe that factor should weigh in Officer Rolfe's favor. Lastly, with respect to intimidating witnesses, again, there is the Ayala factor speaks of a significant risk of intimidating witnesses. I would offer to the court again, there is no risk of Officer Rolfe intimidating witnesses. Given the facts and circumstances of this case, he certainly does not wish to have any contact with any potential witnesses in this matter. Mr. Rolfe has a defense team that is working on his behalf. There's no need for him to contact any witnesses, much less intimidate witnesses. I will tell you that Officer Rolfe certainly looks forward to defending this matter and has no inclination to do anything that would impair that or impede that or obstruct justice in any manner. As we clearly maintain his innocence in this matter, we'll obviously resolve those facts down the road, but certainly there is no significant risk of intimidating any witnesses in this case. Your Honor, we believe all of these factors militate in favor of the court granting a bond to Officer Rolfe. Again, he's anxious to begin the process of defending this matter and addressing the allegations made against him, and we'd ask this court to impose a reasonable bond in this matter.
What does the defense suggest?
I'm sorry?
What type of bond does the defense suggest?
I'm having a little trouble here, but
I'm sorry. What type of bond? What are
he
you
suggested the
requesting?
bond?
Yes.
Your Honor, what I would indicate is that there's a co-defendant in this matter. That the state, in that case, agreed to a $50,000 signature bond. That co-defendant, with respect to certainly certain elements of this particular case, is similarly situated. That he obviously is not charged with murder, but he was part of the process that was out attempting to arrest Mr. Brooks that night. He's similarly situated. If the state believes that, or at least the state believed in that case that a $50,000 signature bond was appropriate, we would suggest a $50,000 signature bond for Mr. Rolfe would be appropriate in this case.
Okay. Will it be Ms. Griffin or Mr. Rucker? Would you like to proceed?
Good afternoon, Your Honor.
Good afternoon.
Can you hear me okay?
I can hear you just fine.
Okay. I am, like Mr. Thomas, having just a little difficulty hearing you clearly, but I'm going to lean forward and see if I can do a little bit better.
Okay.
For the record, I'd like to identify myself as Clint Rucker, and I'm an executive assistant district attorney in the Fulton County District Attorney's Office. I am assisted in this bond hearing by Ms. Salida Griffin, who also is an executive assistant DA in the same office. And Judge, I appreciate you going through these lengths to get us together. And before I get started with my remarks, I want to say good afternoon to all counsel that are on the Zoom. I'm only showing 5 screens on my device, but I am sure there are many more people who are participating. The first thing, Judge, I would like to do is I would like to make some opening remarks, if that would be okay with the court. And then I would like to go over what the statutory and the legal factors are for the court to consider. And then I would like to address in a rebuttal type fashion some of the arguments made by Mr. Thomas and Mr. Pines. And then I would make a short closing statement. And before that, I would ask the court, as part of my presentation, allow me to introduce the widow of Mr. Brooks to make a victim statement, which is allowed under the Victims' Rights Act, to the court in consideration of the setting of bond in this case.
I would hear from her, absolutely.
Okay. And Judge, in the very beginning of the proceeding, when you kind of was laying out some protocols for us, did I hear you correctly to say that you were not anticipating the calling of any witnesses?
That is exactly what I said.
Okay. Just for the court's just edification, the state had prepared to call 2 witnesses. One would have been an investigator with our office, who would have dealt with some of the arguments that were laid out in defense counsel's brief. And he touched on them kind of very lightly in his argument, although he didn't really jump in the way he did when he filed his brief. And so as a manner to rebut some of those statements contained in the brief, we had prepared to call the lead investigator from our office who kind of worked this case up. But as I understand it, the court is not going to allow any consideration of those factors, and so we won't be able to call that witness.
I'll consider a proffer, Mr. Rucker.
Okay, all right, good enough. I don't think that there is anyone who is participating in this process, Your Honor, that takes the circumstances that bring us here today lightly. I certainly don't. And this is a very important case. It's a very significant case. I do take issue with Mr. Thomas's characterization where he says that, you know, it's kind of a case that is a little unusual in its factual scenario. There are many cases like this that the office has investigated through the Public Integrity Unit, and there is nothing unusual about the fact that Mr. Howard decided to file charges prior to the completion of the GBI investigation. In fact, that has happened a number of times in recent history. I don't want to politicize this case. I don't want to politicize this hearing. I would like to stick primarily to rebutting what the defense counsel have said and to discuss the factors for consideration by the court.
Thank you.
Now, I believe that the opening statement given by Mr. Pines was fairly accurate. I believe that the 41-minute encounter between Mr. Rayshard Brooks, and who's the victim in this case, and First Officer Devin Brosnan and Officer Garret Rolfe was cordial for the most part. I don't believe there was any display on the part of Mr. Brooks that would have been violent or antagonistic for those 41 minutes. We do know that during those 41 minutes, Mr. Brooks was actually physically searched, gave his consent to be searched by Officer Rolfe, and that no weapons were found on his person. We do know that at the time that Officer Rolfe attempted to handcuff Mr. Brooks, he did not instruct him as required by the Atlanta Police Department's standard operating procedures, their policies. When you are effectuating a DUI arrest, you are supposed to instruct very specifically the suspect that he is under arrest. And those words were never uttered by Officer Rolfe. So a situation that escalated very quickly, in my opinion, unnecessarily, perhaps could have been prevented with what the Atlanta Police Department teaches in its police academy when it trains its officers, is a term that they call verbal judo, meaning you can talk through scenarios to de-escalate situations. And that simply was not done in this case. Now, I am not excusing the actions of Mr. Brooks. And certainly if he were here today, perhaps those matters would be taken up under a different kind of proceeding. But what I am here to say is that the shooting of Mr. Brooks in the back by Officer Rolfe was not justified. Because at the time that Officer Rolfe shot Mr. Brooks twice in the back, Mr. Brooks was not immediately a physical threat to Officer Rolfe in any way. He was running away. The taser was not pointed at Officer Rolfe, and he presented no danger to Officer Rolfe. And I've heard lots of references from Mr. Thomas about the professional nature of Officer Rolfe's police experience. I would concur. He is a well-trained officer. And he had no justification for shooting Mr. Brooks. Now, I do want to say that as it relates to the factors that the court has to consider with respect to this case, my argument to the court would be that we have not been presented with any evidence of Garret Rolfe's significant ties to the community. What you have heard by way of proffer and by way of several letters is that I've known Garret Rolfe for a long time. I think he's a great officer, and I don't think he would flee. But where is the evidence that shows, as the case law states, and I would cite the court to specifically cases that we provided in a response brief about 2 hours ago. In as much as we got the written brief from defense counsel yesterday morning, we tried to put together a response and give the court a couple of cases that we would rely on so that you could perhaps have an opportunity to review them prior to today's hearing. But one of the factors that is very, very important for the court to consider is contained in the case of Dunn versus Edwards. It's a Supreme Court of Georgia case. It was decided, it's well-established law, 2002. It's 275 Georgia 458. And in Dunn, they refer to Ayala versus the state, which, as all parties here, I'm sure, are aware, is the controlling seminal case that deals with the factors for the setting of bond for a homicide case. If you look at the underneath the opinion, under footnote 1, headnote 3, it says the court stated in Ayala that evidence demonstrating ties to the community would include the length and character of residence in the community. As of this date, there is no evidence to show that Officer Rolfe, prior to turning himself in, actually lived in our jurisdiction, that he owned property in our jurisdiction, that he has family members that are in our jurisdiction. What I heard is that he is a lifelong resident of the state of Georgia. Where? Is he outside the court's jurisdiction? Should he not appear in court, that the court would have the power to compel him to come? There's no evidence of that. The case goes on to say that the employment status and the history of the defendant should be taken into account. And so we know that Officer Rolfe was a 7-year police officer. We know that he was trained in drug recognition. We know that many of his colleagues are very fond of him. But the fact is that the mayor and the Atlanta Police Department terminated Officer Rolfe's employment within 24 hours after looking at the videotape that we have submitted to the court as part of our responsive brief. It has been described, his actions that is, as excessive, unnecessary, and actually characterized as murder. And that is because, Your Honor, the videotape is clear. This dispute that Mr. Thomas claims that we have about the facts of the case is really no dispute at all. And I know that we are not here to decide the merits of the case, but the reality is that the strength of the case is strong. It's so strong that it would provide a motivation for Officer Rolfe to flee this jurisdiction to avoid criminal prosecution. He certainly now has the means, which was not discussed in the defense presentation, because we know that he has received upwards of $250,000 in cash donations. We have not heard anything about the surrendering of any passport that he may possess, or any other conditions that would give the court some confidence that Officer Rolfe would not be a risk to not appear in court. The reality is he does not have a job. He is not employed anywhere else. He has no income or any of the things that traditionally the court would look at that says, hey, this guy is a good risk for me if I gave him a bond, because he's got these things that connect him very closely to the community. We just quite frankly haven't heard it. The other factors that the court looks at is past history of responding to legal process. I don't take issue with that. Or prior criminal record, and I don't take issue with that. But the reason why I brought that up to the court is because when you look at Ayala versus the state, it's very, very clear. And Ayala says that the burden shifts to the state to show by a preponderance of the evidence that the defendant is not entitled to a bond once the defense has established these close ties to the community. My first argument to the court is that that has not been done. But my rebuttal will be that under Ayala, my contention is that Officer Rolfe poses a risk, a significant risk in this case. And the risk that I am alleging that he poses is, one, he is a significant risk to intimidate and or influence witnesses should he be granted a bond. What the court doesn't know is that in this case, the Atlanta Police Department has a policy that all officers sign off to. The policy states that if you are the subject of a pending investigation, you cannot talk to other officers about the investigation while it is pending. In this case, we have executed search warrants and obtained the cell phones for both Officer Rolfe and Officer Brosnan. We have obtained cell phone records for those two cell phones. My investigator, should I have put him up and let the court hear from him, would have said that upon reviewing of those cell phone records for Officer Rolfe, he was able to determine that in the minutes after this incident, there were multiple text messages exchanged between Officer Rolfe and 4 different Atlanta police officers. My investigator is prohibited from viewing the content of those text messages because Officer Rolfe, through his attorneys, has refused to turn over the passcode for his phone, despite the fact we have asked.
Your Honor?
Yes.
May we object to that? First of all, that's completely improper to comment on a defendant's right to remain silent. That is, privilege still applies in a bond hearing, and it is just completely improper for the DA's office in this public forum to mention that our client is relying on his constitutional rights to remain silent.
All right.
So we would ask that you not consider that, Your Honor.
All right,
May I respond?
Yes. Yes, if you heard me.
Okay. Does the court have the case that I sent as part of my responsive brief that is entitled State versus Stahl?
I do.
STAHL?
I do.
It is a Court of Appeal case from the Second Circuit the state of Florida. It was decided very recently in 2016. This was the holding in the case. The trial court erred by denying the state's motion to compel the production of the passcode to unlock the defendant's cell phone based on the Fifth Amendment privilege because it departed from the requirements of the law by considering only part of the standard used to determine whether a communication is testimonial and by burdening the state with proving the existence of incriminating content on the defendant's phone when that was not at issue, and further departed by requiring the state to establish existence beyond the reasonable particularity standard. And that is what I am asking in this case.
Asking what, sir? This isn't a motion to compel.
Say it one more time, Your Honor.
This isn't a motion to compel, Mr. Rucker.
I understand.
I'm missing the connection.
But I understand. But as a condition of bond, to prevent any intimidation or influence of witnesses, I am orally asking the court to compel, if the court is inclined to grant bond, that as a condition of bond, we be provided with the passcode and not be prevented from evidence, and that Officer Rolfe not be allowed to conceal is a very strong word, but prevent us from getting the information that we are legally entitled to.
Anything further?
The court has heard an argument from Mr. Thomas that the letters, the character letters, tie him to the community, and that he should be entitled to a bond. I would like to point the court to the statute 1761, where I am sure the court is very aware that that really is an inaccurate statement. There is no entitlement to bond when the defendant is charged with murder. A superior court judge is authorized and may, under certain circumstances, grant a bond to the defendant if they meet the four factors: that he poses no significant risk of fleeing or failing to appear in court, he poses no significant threat or danger to any person, to the community, he poses no significant risk of committing any felony pending trial, and he poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. My first contention is that, one, we don't have significant ties to the community that have been proven by any competent evidence. Secondly, I contend that the secreting of the text messages right after this investigation to other officers, potentially in violation of the Atlanta Police Department's policy, would allow the intimidation of witnesses and obstruct the fair administration of justice in this case. Now, one of the other contentions that I'd like to rebut is that Mr. Thomas gave the court a very long list of names of persons who have submitted letters in support of Officer Rolfe by way of attesting to his character, the way he treats suspects with the utmost respect, was a quote that I wrote down, and that he was a veteran police officer. I would state in my place, and as part of our responsive brief, one of the things we did submit to the court was a still photograph that was taken from a videotape of a witness from the scene. In this case, the state has reviewed upwards of 8 different videotapes of this incident. Not all of them have been made public. We've also interviewed upwards of 8 different witnesses in the case who were there, present, and witnessed various parts of this incident. Had my investigator been able to testify, Judge, I expected he would have told you that the videotape was not altered. It was only enhanced, meaning it was zoomed in so you can see it really clearly. And it shows the kicking motion made by Officer Rolfe to Mr. Brooks's body while he was down on the ground after he had been shot by Officer Rolfe. That does not show good character, Your Honor. That has been alleged by Mr. Thomas. It doesn't show, consistent with those letters, that Officer Rolfe treated Mr. Brooks with the utmost respect after he shot him. And what the defense doesn't know is that a witness at the scene corroborates the videotape. We charged Officer Rolfe with a violation of his oath because his policy states mechanisms that you can use to physically restrain a suspect. And in this case, they were not followed by Officer Rolfe. The good character that the defense wants you to consider in giving him a bond, I am saying to the court, there is rebuttal evidence to the contrary. And it is captured on videotape so that you can see it for yourself. And after Officer Rolfe shot Mr. Brooks and Mr. Brooks went down, the videotape will show you, Your Honor, that it was upwards of 2 minutes before Officer Rolfe did anything in an attempt to help Mr. Brooks. And it was only after another police officer arrived on scene that Officer Rolfe even went to go get some bandages to try to help Mr. Brooks. What you'll see on the videotape is that he and Officer Brosnan just stand over his body and just look at it. Not professional, not good character, and in violation of the Atlanta Police Department's policy, which requires in a use of force situation that the officer render medical aid in a timely manner. What is timely, of course, ultimately may prove to be a jury question. My contention is that when you're standing there watching the man gasp for breath, it doesn't show me any good character that's been alleged that you treat suspects, all suspects, with the utmost respect, such that the court can trust you to come back if they gave you a bond. As part of the presentation, Your Honor, I would have expected my investigator, who for the record is Investigator Donald Hanna, to indicate to the court that while the court is not here to consider the facts of the case, my contention that the evidence is so strong that Officer Rolfe would have a motivation to avoid a trial, in this case by fleeing, centers primarily on the Fulton County DA's office attendance at the autopsy of Mr. Brooks, which was conducted the next day, wherein the medical examiner indicated that Mr. Brooks was shot twice in the back. I would have expected her to testify here today that Mr. Brooks's back was facing the muzzle of the gun at the time that he received those gunshot entry wounds. One went in his upper back 1 inch to the left of his spine. The second bullet went in through his left buttocks and came out the front right above his pubic area. The thing that is significant about that is this. The contention by Mr. Pines in his opening remarks that Officer Rolfe shot Mr. Brooks right after he pointed the taser at him is just not supported by the video. And what the medical examiner would have testified very significantly is that Mr. Brooks had his spinal cord hit by the bullet that entered his upper back. And it would have rendered him, his legs, useless. But the videotape shows that Mr. Brooks was some 18 feet away from Officer Rolfe at the time that he received these gunshot wounds, which was some 15 feet away from where he was when he reached back to deploy the taser that went up into the air. The video shows that Officer Rolfe didn't even have his gun drawn at the time that Mr. Brooks reached back with his arm and pulled the taser that went up into the air. He waited for his back to turn before he shot him. Doesn't sound like good character to me, Judge. And the video doesn't lie. And so the state is here, Your Honor, asking the court to deny bond in this matter.
All right, and Mr. Rucker, if you can hear me, just a couple of questions for the state.
Yes.
First of all, if the court, assume for the sake of argument that the court would grant a bond, what would the state be looking for?
$1 million with conditions.
And those conditions, please, sir.
That the defendant discloses to the court his resident location and who he is living with. That the defendant would give up the passcode to his phone. That the defendant would have no contact with any officers from the scene. That being the scene at the Wendy's on June the 12th, 2020. That the officer would turn over any communications, text mails, emails between himself and other officers since the date of this incident. That the defendant would be fitted with an ankle monitor. That the court would impose a curfew from 6 a.m. to 6 p.m., and the exceptions would be to visit his attorneys, to potentially work, to potentially worship, or for any medical issue. And if there were instances that required something other than the court's conditions, that the state and the court would be notified by defense counsel prior to.
Can I just clarify, when you say curfew, do you mean from 6 p.m. to 6 a.m.?
He can be out.
Okay, you said curfew 6 a.m. to 6 p.m. Did you mean 6 p.m. to 6 a.m.? So in other words, he He would
Yes,
be.
yes, I understand what you're saying. Yes, that is what I meant.
Okay, okay.
Yes, ma'am.
Okay, gotcha.
That the defendant would turn over his passport, that the defendant would not possess any weapons, no guns, no knives, no rifles, and that the defendant or the defendant himself or through any third parties, there would not be any communication with the family members for Mr. Rayshard Brooks. Or for that matter, any witness in this case.
By that, Mr. Rucker, do you mean the defendant personally? You do not mean his attorneys?
That's correct.
Okay. All right, anything else?
Would the court please hear an impact statement from Mrs. Tamika Miller? And then I would make a few closing statements and then I would be finished.
Okay. Yes, I will. And Mr. Rucker, I assume that you are the victim's advocate. It has instructed her as to what's appropriate for a bond hearing.
Yes, ma'am.
Okay. I will certainly hear from her, and could you please help me find where she is on the camera tile or the computer?
Hello, Your Honor.
Hey. Oh, okay. Hey, Ms. Miller, I got you.
Hello. Hello, everyone. I'm going to do my best without becoming emotional. I'm Rayshard's widow. I never thought I would be saying that right now. And this is just a lot to take in for me mentally, physically, emotionally. It's only been a few weeks since my husband been gone and murdered. And just a week before I laid him to rest. My daughter's birthday was that week that he was killed. And my anniversary was the next day. It was the next day. Father's Day came up. Our wedding anniversary was on the 14th. My life has completely turned upside down since this has happened. I've been unable to sleep, eat, or even console my children. But I feel today the court wants to be able to let the defendant bond.
Ma'am, could you say that again?
The defendant, you guys want to be able to give a decision whether he should be able or allowed to bond. And I say no to it. I say no. Because mentally I'm not able to handle it. The defendant has already shown that he's a danger to the community. I watched as they kicked my husband and stood over his body and stood on his shoulder. And I could just only imagine how scared he was and what he felt at that time. But I feel with even killing him wasn't enough. Because they stood there and did nothing when something could have been done to save him, and at least he could have made it home to his children, to his family. To fulfill promises that he made to me and my daughter earlier that day.
You okay, Ms. Miller?
My family has suffered so much dealing with this, and it being public and everything. It's just been so hard dealing with everything. I can't finish. Can I please step away?
Of course.
I'm sorry, Your Honor. Can I just have a minute, please?
Of course.
Yes.
Take a minute.
I apologize, Your Honor. I can't hear you. My husband, Rayshard Brooks, just to let you know a little bit about him, because nobody got to see who he was. He was a loving, caring, silly, wonderful father, and the best husband I could ask for. He had the brightest smile and the biggest heart. He loved his family. He was only 27 years old. And he had so much to live for. So much. Now I'm forced to be a single mother, and I forever have to explain to my kids that daddy would never, ever come home. He won't be a phone call away. I'll struggle raising my kids on a one-parent income. I'll never be able to get that help or support that I need because my husband has been taken away. My husband did not deserve to die. And I should not have to live in fear while waiting for the man who killed my husband to be tried in court. This defendant should not be treated like anyone else who is accused of taking someone's life without remorse. Considering the victim, considering the violence, the violent nature of the whole scene. I feel like he had complete disregard for my husband's life. Or any other body that was standing out there. Because there was 3 shots fired and only 2 entered my husband. And it could have been someone else's child or somebody else who could have been hurt that day. And I thank God that it wasn't. I can't sleep at night because I'm scared. And if he was released, I could only imagine where my mental state would be. I would be so scared because I don't know what they would do. I can't even go outside of my house now because so many people said hateful things. My husband wasn't perfect, but he didn't deserve to die. And I'm just so confused because 41 minutes of a conversation felt like he was being harassed. You could have already told him, hey, sir, we smell it on you. We're going to lock you up for this and that. And it could have been summed up from there. But instead, I feel like he was harassed and played with the whole time. So, Your Honor, I'm asking that the bond does not be granted due to my health, my mental state. I have to still raise my children. I don't have a big support group. It's just me and my children. That's all I have. My best friend has been taken. My helpmate has been taken. And never in a million years I would imagine myself being called a widow.
Ms. Miller, I want to thank you. I don't know if you can hear me, but I want to thank you for speaking to us today. And I heard you. All right. Thank you, ma'am.
Thank you.
Mr. Rucker?
Yes, thank you, Judge. In conclusion, I would just say to the court that under OCGA section 1761, 2E, amongst other things that the statute lays out for the court to consider, the accused's financial resources and other assets, the earnings and income, the financial obligations, the purpose of bail, and any other factor that the court deems appropriate. The setting of bail by a Superior Court judge, as you know, Your Honor, is discretionary. It is not mandated by law. We are here asking the court to deny bond in this matter. And some factors that the court can consider is that, one, we expect, based on Justice Melton's judicial emergency order, that we would be able to convene grand juries in a few months. And potentially this issue of bond can be revisited again. We know now from the impact statement that the Brooks family will suffer more emotional harm should the defendant be granted a bond and allowed to not be in custody. And I would say, Your Honor, that the court can also consider the potential harm to the entire community in the consideration in this matter. If the court is so inclined to set a bond in this case, one additional condition I would ask from the court is that as part of the condition of bond that we know from the experts that the phone that is in question that I have talked about during my presentation can be erased or wiped remotely. So even though I have physical custody of the phone, it can be erased or wiped remotely from another location. I would ask the court to condition bond that not occur. And I want to thank the court for giving us time to make our presentation.
Any response, Mr. Pines?
Your Honor, I do have argument for the court, but I know we're going a little long and the court has other matters. So is there anything particular you want me to address, or may I just respond?
I'm anxious for you to respond. I will say that I did not hear anything with regard to financial ability.
The financial ability to make a bond, Your Honor?
Yes.
Okay, so Mr. Rucker is correct that the city of Atlanta did fire Garret Rolfe, so he did get fired. However, Mr. Rucker did make mention that there has been a fundraiser for Garret Rolfe, the same way there has been a fundraiser for the Brooks family. These are just people in the public who are donating money. None of that money is in the possession of Garret Rolfe. It's either in the possession of the people who raised the money or escrow accounts. But if the court is not inclined to grant a signature bond, then Officer Rolfe can make, or Garret Rolfe can make a reasonable bond in this case. Just as a little bit of a comparison, I know that the district attorney's office says that they've prosecuted and are prosecuting other police officers. None of those police officers are still in jail. I believe the last police officer to be released was Officer Burns, who was given a $240,000 bond by Judge Woodson back when magistrates were giving bonds on murder cases. If the court's not inclined to give a signature bond, we would ask for a bond in the range of $50,000 to $100,000, that being a good bond, either through property, surety, or bonding company, or cash, whichever way that the court would like to do that. Obviously, we'd rather a surety bond if possible, so that he can use a commercial bonding company. Or, as you know, the Fulton County Jail has a 10% program. That's always an option for the court, too. But do you want me to address some of the factors, or I guess some of the stipulations that the state would like to put on the bond, or would you like me to address some of the arguments that they made?
Mr. Pines, I'd like you to respond. That what you address is totally up to you.
Thank you, Your Honor. So let me just kind of go back from the beginning. 1761 actually doesn't talk about ties to the community. It's not a factor under the statute. It is under Ayala. But through what Mr. Thomas told this court, Garret Rolfe has tons of ties to this community. He was born here. He was raised here. He went to school here. He was employed here. We did not tell you where he lived, although I think that one of the character letters did say that Officer Rolfe did live in the city of Atlanta at some point prior to this incident. But of course, we will disclose in confidence where he will be living, but we do not want that public for his safety, the same way that, that the Brooks family doesn't want their information to be out there in the public. So he has tremendous ties here. Everything is here in the state of Georgia. If you like his passport, we would surrender his passport. That's not a big deal. The state in its argument is that this is not a justified shooting. It's clear as day, and therefore he has every reason to run. And so I have to rebut that because that's an argument that they made, to Your Honor. So whether a grand jury decides if this is justified as they're required to do under the law when this case is presented, and just so the court knows, Paul Howard in his press conference said that this case would not be presented to a grand jury until January or February of 2021 because there are 7 other cases ahead of it, and that's in his press conference. But when this case is presented to a grand jury or a judge during an immunity hearing or even a jury, there's a justification defense and that Garret Rolfe is entitled to. And 17420 talks about when deadly force can be used in an arrest. And it says that deadly force can be used for a suspected felon. And in our brief, Your Honor, we gave you a memo from the Atlanta Police Department that outlines at least 5 different felonies that Mr. Brooks committed that night. 1 was punching Officer Rolfe in the face. 2 was stealing Officer Brosnan's taser. 3 was pointing the taser at Officer Brosnan. 4, although I don't know that the officers knew it at the time, it's actually a felony to take a weapon from a police officer. Mr. Brooks was a convicted felon. He can't possess a weapon, even a taser. And then, of course, he fired the taser at Officer Rolfe. So it's clear that he was a suspected felon. And so the only other indication under the law that says whether our client can use deadly force is whether the suspect possesses a deadly weapon or any object, device, or instrument which, when used offensively against the person, is likely to or actually does result in serious bodily injury. And also in the brief that we filed, we attached a warrant, and that warrant was sworn out